I am here today to speak with Sharon Brown, a principal attorney here with the Pacific Legal Foundation. Ms. Brown has just filed an amicus brief in the Rowland Unified School District versus the Walnut Valley Unified School District on behalf of Parents for Choice and Senator Bob Huff. Ms. Brown, why is Pacific Legal Foundation participating in this case?
Education is one of the most important functions provided by the state of California. Oftentimes, a public school education depends upon where parents or guardians live. In 1993, the legislature adopted the School District of Choice Act to empower parents to choose a school district that best meets the educational needs of their children. Under the act, once a school district designates itself to be a school district of choice, it agrees to enroll students from neighboring school districts without those parents having to seek permission from the school district of residence.
What are some of the major concerns of parents regarding District of Choice Act?
As a result of the District of Choice Act, parents of all income levels and ethnicity are able to choose the schools that best meet the needs of their children. Additional benefits include that school districts need to compete for enrollment of students. If they do not have sufficient programs or their schools are not good, the parents are going to leave those school districts for a district of choice. It also gives rural school districts an opportunity to have greater educational programs because they are able to have more students enroll in their schools. Last, it makes sure, and importantly, it allows parents to enroll their children in schools that have good programs, and these students are not forced to stay in underperforming schools.
How is the District of Choice Act being challenged?
In 1994, Walnut Valley Unified School District declared itself to be a school district of choice so that it could enroll students from neighboring school districts into their blue ribbon schools. Over 500 Rowland parents have decided to enroll their children into Walnut Valley schools. Rowland Unified School District filed a lawsuit to block these students from enrolling in Walnut Valley schools. Rowland is relying upon a provision of the act which will cap the number of students that can be enrolled in a school district of choice to 10% of the average daily attendance. According to Rowland, this means that all students that have ever transferred to a school district of choice must be counted. And once that 10% cap is reached, no further could a student transfer from Rowland to a school district of choice.
What action is the foundation taking to defend the District Choice Act?
In our amicus brief, we examined the legislative history of the 10% cap, and we discovered that it was actually a rolling cap. In other words, the 10% cap will fluctuate based upon the average daily attendance of the current year. It does not go back to 1993. And this really does make good sense because students will graduate, they will leave a school district to go to a private school, they unfortunately will even drop out of school or will return to their school district of residence. In our amicus brief, it recognizes that the district of choice is an important part of providing a good public education to the students in California. And it focuses on the needs of students to have their parents involved in selecting the schools that best meets their needs. It really is unfair for a school district of residence to hold students hostage based upon a zip code or an attendance zone or based upon being forced to stay in an underperforming school. The School District of Choice Act provides parents with this necessary choice. Thank you.
For more PLF videos, visit our YouTube channel.